All right, Mr. Fields, are you able to hear me okay?
Yes.
Okay, and looks like we have Mr. Horowitz and Mr. Ziegler connected, so we'll go on the record. This is People versus Daly and Fields case. This is Kalkaska, case number 234870. The record should reflect Mr. Fields is present today by Zoom video from Ingham County Jail. If I could have both counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr. Fields.
All right, we're on the record today for entry of a plea. Mr. Horowitz, do we have a plea agreement that we need to put on the record today?
There is, Your Honor. The people are agreeing to allow Mr. Fields to plead guilty to counts 2 and 3 under HIDA, and the remaining would be dismissed.
All right, and Mr. Ziegler, I'm conducting this hearing from Crawford County, so I don't have the file. Can you tell me which 2 counts those are and what the maximum penalties are?
Your Honor, count 2 would be an attempted breaking and entering a building with intent. That would be a 5-year maximum felony. Count 3 would be police officer assaulting, resisting, obstructing. That would be a 2-year max and or $2,000 fine.
Okay, Mr. Horowitz, is that correct from your understanding?
It is, Your Honor.
Okay, Mr. Fields, were you able to hear all of that?
Yeah. Yes, sir.
Okay, have you had a chance to speak with Mr. Horowitz about this plea agreement?
Yeah. I think it's supposed to be high probation.
Correct, yep.
Okay. Yeah, I spoke to him about it.
Is that how you want to proceed today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Fields, are you currently on any kind of probation or parole?
No, sir.
All right, and as Mr. Ziegler indicated, the maximum possible penalty that you can face for attempted breaking and entering with intent is up to 5 years. Do you understand that?
Yes, sir.
And the maximum possible penalty you could face for resisting and obstructing is up to 2 years. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
And I attempted to break into a dispensary, and I attempted to run from the officers.
Yeah, so I'll ask you some more specific questions about what happened, but you're going to plead guilty to both of those charges today, is that correct?
Yes, sir.
Okay. Right now, I'm going to go through your rights. I want to make sure you understand the rights that you're going to be giving up by entering this guilty plea. So right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty, including the right to have a trial.
Yes, sir, Your Honor.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get the plea reversed, you'd have to ask the next higher court up, which is the Court of Appeals. You have to ask them to hear your case. If they said no, then that would be the end of any appeal. Do you understand that?
Yes, sir, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, sir, Your Honor.
Has anyone promised you anything other than what we said here today on the record?
No, sir, Your Honor.
Is it your own free choice to plead guilty?
Yes, sir, Your Honor.
And are you pleading guilty because you are guilty?
Yes, sir, Your Honor.
Thank you. So, Mr. Horowitz, again, I don't have the file, and I don't have a copy of the information. So can you conduct some questioning of your client to establish a factual basis, please?
It was a little hard to get it off mute there. Your Honor, I don't know how the court feels about it, but may I defer to Mr. Ziegler for the factual basis if he has questions? If not, I'll find the police report and see what.
I can do that.
Sure.
Your Honor.
All right, thank you.
Mr. Fields, on or about February 18th of 2023, were you in Kalkaska County?
Yes, sir, Your Honor.
And did you have an occasion to be at the Green Farm store in Kalkaska?
Yes, sir.
Did you attempt to enter that store?
Yes, sir.
And that store was closed to the public at the time?
Yes, sir.
Did you use some kind of crowbar or pry bar along with some others to attempt to enter the building?
Yes, sir.
At some point, did you hear police coming or did police arrive?
I didn't hear. They just got behind us.
Okay. At some point, you drove away from the police, correct?
I didn't drive away from police.
Okay. At some point, did the police give you some kind of command?
Yes.
Did they tell you to stop fleeing from them,
No.
either in the vehicle or on foot?
They had to be on foot, yes, sir.
Okay. And you continued to flee from police on foot at least for some time. Is that correct?
Yes, sir.
And you knew that they were law enforcement officers performing their duties?
Yes, sir.
Your Honor, I believe that would establish all of the elements.
All right, thank you. Mr. Fields, was it your purpose in breaking into that green farm? Were you going to take something that was located inside that building?
Yes, sir.
Okay. All right, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. Fields is guilty of each of these charges. The court will accept the guilty plea as to both. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Horowitz, are you?
No, Your Honor.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Horowitz?
Yes, Your Honor.
All right, thank you. Mr. Fields, the court will set this matter for a sentencing hearing. Do you know how long you're going to be there in Ingham County?
I should be leaving here soon on higher probation too.
Sorry, I couldn't quite hear that. Do you know how long you're going to be there?
No, I don't. I really should be leaving soon on higher probation though.
Okay. So, Mr. Ziegler, if you can prepare a writ. Mr. Fields, you do have the right to have the sentencing hearing in person. And if you wanted to do that, the court would sign an order to have you transported to Kalkaska County so that you could be present in the courtroom for sentencing. You can also waive that right, and we can do that by video from Ingham County Jail if you're still located there. Do you know which of those?
I really do it by Ingham County Jail.
Okay, so the record will reflect that Mr. Fields has waived his right to an in-person hearing, and so Mr. Ziegler, if you can do a writ from Ingham County for a Zoom sentencing. And then Mr. Fields, somebody from the probation department in Kalkaska will be in touch with you for a pre-sentence report.
Okay.
Mr. Horowitz, anything further we need to address from your side today?
Just for the record, Your Honor, at the last hearing where Mr. Fields was not produced. He had been transported to Kalkaska. That writ had been issued and had been delivered upon, and there was just some miscommunication on the Kalkaska end. It very well could have been on my end, but I just wanted to let the record know that efforts were made to get him to Kalkaska, and he was in fact transported.
Okay, thank you. Mr. Ziegler, anything further from your side today?
No, Your Honor.
Okay, thank you. That concludes this hearing. All parties on this case are free to disconnect at this time.
Thank you, Judge.
We're on the record in People versus William Lamont, two files up for hearing today, case number 194499 and 225099. The record should reflect Mr. Lamont's present here in court today. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Mr. Lamont.
For evidentiary hearing on alleged probation violations of both files. Trish, are we going to be proceeding with the hearing today?
We are, Your Honor.
Ms. Pope, did you want to make any kind of opening statement?
No, Your Honor, but I would ask the court to take judicial notice that there are probation orders in both files that require defendant not violate state law or commit assaultive behavior. And that Michael McFalda is his probation officer. Just cut down the time. I spoke to defense counsel about it.
Any objection to that?
No, we would agree that those are factually accurate statements.
Okay. Mr. Church, did you want to make any kind of opening?
No.
Ms. Pope, your first witness.
Your Honor, the people called Bethany Lamont.
Lamont, come forward, please. I'm going to have you sit in this chair, but before you're seated, I need to swear you in, so please raise your right hand. Do you solemnly swear or affirm the testimony you're about to get up will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Please be seated. Please state your first and last name, spell both.
Bethany Lamont, BTHANY,
Thank you. Proceed when you're ready, Ms. Pope.
Ms. Lamont, you have testified in this matter before.
Can you speak up a little bit, Ms. Pope?
Yes, you have testified regarding these incidents before, have you not? Yes, ma'am. How do you know William Lamont? My husband. Okay, and how long have you known him? 2 years. What was your relationship with him on July 20th, 2023?
I was living with him and his parents. We were married.
Where were you living at?
Frederick Street with his parents.
And that's in Crawford County.
Yes, ma'am.
And who lived in the home?
His father, William, and his mother, Carrie, my husband, William, and myself.
And William, who is the defendant here sitting at defense counsel, does he have a name that he goes by?
Ed.
What is that?
Ed.
Okay, thank you.
On July 20th, 2023, did something happen?
Yes, ma'am.
Can you tell me what happened?
I was in the room to get dressed. I was looking for my coffee cups, couldn't find my coffee cups. My husband got upset, started yelling at his father, saying that him and his mother steal our stuff and throw our stuff out. I go in the bedroom to get dressed and I walk out to a hearing motion, and my husband has his father pinned on the floor on top of my husband with his arms around his neck.
What time of the day was this?
Approximately 4:30 a.m. I was getting ready for work.
And where was this at, in the living room?
The living room, dining room area, it was like in the middle.
And describe how your husband Ed had his arm around his father's neck.
He had both of his arms locked around his neck and was screaming, "Go to sleep, old man, go to sleep."
Did William Lamont Sr., did he say anything during this altercation?
No, ma'am, I don't think that he could. He was red in the face.
Was he doing anything? Can you describe what William Lamont Sr. was doing?
I would like to clarify, he is not a senior.
Okay.
But he wasn't really doing anything because it's a son. It's his, he'll defend his son to death. He won't fight it with his son. Other than, unless Ed's attacking his mother, his dad will not stop him.
And did this appear to you as a playful interaction or a consensual interaction?
No, ma'am. My father-in-law's shoe was several feet away from him, so I knew that my husband dragged his father on top of him.
What happened after you witnessed this event?
I tried to get my husband to let go of his father, and whenever I grabbed my husband's arm and was pulling on it, I honestly do not believe it was intentional because there was force behind it, but he backhanded me and he let go of his father. His father rolled over and was just crying, "Please, son, stop. You don't have to do this."
When he backhanded you, was it while he was assaulting his father?
Yes, ma'am. Because I was pulling his arm and he had force around his father.
How did this incident make you feel?
Terrified. I got sent home from work. I came up to the courthouse. I spoke to his probation officer who instructed me to go speak to the police because I didn't know what to do. I was distraught.
Is William Lamont, is he normally up at 4:30 a.m.?
He was to take me to work. He always took me to work.
How did this incident end?
They wound up both taking me to work and while I was at work, his father and mother came in and spoke to me in front of one of my coworkers in front of, I was working at the Easy Mart at the time, and spoke to me in front of self-checkout, and they both admitted that one day he's going to kill somebody. And I was terrified. I couldn't even finish out my job. I didn't know what to do. I wanted to get help for my husband because he's not mentally stable.
Who was the coworker that they said this in front of?
Her name was Brittany, and she's no longer working with us or working with them. Neither her nor I.
Have you talked to the defendant about that incident since it happened?
Yes, ma'am, and according to them, I took it the wrong way. That's how they told me that's how they try to get past stuff when there's stuff bothering them. But it's not the first incident that I've seen, but it was enough to scare me.
I have no further questions for Ms. Lamont.
Thank you, Mr. Church.
Thank you, Your Honor. So Ms. Lamont, you described that this happened at 4:30 in the morning,
Approximately, yes, sir.
and you were getting ready for work,
Yes, sir.
and you described there were 4 people in the household,
Yes, sir.
and that was yourself, Ed, his father, and his mother.
Yes.
And you said Ed and his father were in the living room, dining room area.
Yes, sir.
You were in your bedroom?
I was in the back room, yes, sir.
In the back room, is that your bedroom?
Yes, it was where my husband and I stayed.
And where's Ed's mother?
Asleep in her bedroom.
And you described your room as the back room. Where's her room?
Down the hall, past the bathroom, in the laundry room.
And she was asleep?
Yes, sir.
And did she come out during this commotion at all?
No, sir, his mother is an alcoholic and sleeps very hard.
So this commotion caught your attention, but not hers.
Correct.
Now you described that when you went out, they were on the ground wrestling.
I would not call it wrestling because my father-in-law was not making moves to wrestle. It was my husband strictly.
So where is Ed in relation to your father-in-law?
Ed is laying on the floor, his back on the floor, has his father's back up against his chest.
And you described that Ed has his arms around his father's neck.
Yes, sir,
Can you show me how that was again?
like this.
And you said at this time, you could not see Ed's father doing anything or saying anything?
Correct.
Okay, so you can't see him doing anything with his hands. You don't hear him saying anything.
No, sir,
You hear any noise coming from him at all?
not my father-in-law, no.
you said at this point you intervened
Yes, sir.
and you grabbed Ed's arm and were pulling it.
Yes, sir.
Now, you described that when you were pulling this, that you were struck by the hand.
Yes, sir. I do not believe that was intentional, by no means.
So that is to say, you believe that when you were pulling it, essentially at a certain point, you overpowered his arm and pulled it back.
Yes, sir.
So you don't believe that Ed intended to strike you?
No, sir.
Do you think that Ed was trying to strike his father?
I do not believe he was trying to strike his father because he was choking him and he's yelling, "Go to sleep, old man, go to sleep."
So he's yelling this?
Yes,
Now, you described that after you pulled his hand off, his father rolled over,
yes,
and you said he said some things?
yes. After he started gasping for a minute, yes, he was begging his son to please stop.
What happens next?
I get Ed and I get him in the room. I finish getting dressed. They wound up acting like nothing happened and taking me to work.
So how long is it from this to when you get in the car with him?
15, 20 minutes. Because I had to be at work at 5.
And I asked you a bad question there. I made an assumption. Did Ed go with you when you went to work?
Yes, sir.
So in the car were you, Ed, and his father?
Yes,
And is it common for his father to drive you to work?
always.
Why is that?
Because I have epilepsy.
Do you have any mental health diagnoses?
I do. Relevance.
I think it's directly relevant to whether or not she accurately recalls that evening. I mean, it's directly relevant to her credibility.
You're saying that somebody who has mental illness is by virtue of that not credible?
I'm saying it certainly would be something that could affect their credibility. I don't know what the diagnoses are, but I think it's,
I think if you want to ask her if she has any kind of condition, whether it's mental, physical, otherwise that would affect her memory, I think that certainly is relevant. In terms of credibility, I don't think whether or not somebody has a particular mental or physical disability makes them more or less credible. So I like to ask questions as it relates directly to her ability.
do you have any mental health diagnoses that might affect your ability to remember things?
No, sir.
What about Ed? Does he have any mental health diagnoses?
Yes, sir.
Do you know what those are?
I know some of them, yes.
What do you know him to be diagnosed with?
He's got objection relevance.
I mean, I should mention, this is a probation violation hearing under the court rules. Those amendments don't strictly apply, so we can get to the heart of matters. I mean, I'm aware Mr. Lamont's got some mental health issues, so you just want to cover it, chase Mr. Just how it's relevant.
So you're aware that he has some mental health diagnoses?
Yes, sir.
Is his father routinely involved in his treatment of those?
His father takes him to appointments whenever my husband decides to go. He drops him off.
Does he
does not
ever
go in.
engage in the counseling with them?
No, sir.
Has he gone through any training that you know of to be able to help Ed with his disabilities?
They say so, but I have not seen actual evidence.
Fair enough. I don't have any additional questions.
No problem. Thank you. Ms. Lamont, you can step down. Let's go with your next witness.
How do the people call Sergeant Lord?
Come forward, please. Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you. Please be seated. Please state your first and last name and spell both for the record.
Chase Lord, LOHR,
What is your title?
road sergeant,
How long have you been a police officer?
5 years.
Were you working on July 20th, 2023?
Yeah.
And did you interview Deputy Lamont that day?
Yes,
About what time did you interview her?
it was midday. Time I spoke with
You heard her testify today.
her. Yes,
Was her statements to you similar to the things that she told you that day?
similar.
On that day, what did you know that was different?
She informed me that, like you said, the incident occurred about 4:30 a.m. With Ed and Will Lamont. She witnessed that incident occur. She told me that, his face was discolored, but that William was saying for his son to stop also.
Did you speak to William Lamont?
See,
Sorry, did you speak to Ed Lamont?
Yes.
Defendant. Sorry. And when did you speak to him?
It was in the afternoon. They were on their way to pick up that before.
The same day?
Yes.
How did Ed Lamont, and I'm sorry, Ed, I know it's William, the defendant, how did he seem when you spoke with him?
He was willing to speak with me. We talked, about the incident. He said that nothing physical had occurred between him and his dad. But he did indicate that there was an altercation, but a verbal altercation about coffee cups and misplaced property and stuff like that between him and his father.
Did he indicate that him and his father had any type of physical touching or consensual contact?
He denied any physical contact between the two of them.
Did you speak to William Lamont, the older William Lamont?
I attempted to speak with him that day. He was very confrontational towards law enforcement, myself and our detective sergeant who tried to speak with him initially during that traffic stop. I also did attempt to make contact with him via telephone several times, and he did not return my phone calls.
I have no further questions for Sergeant Moore.
Thank you, Mr. Trush.
Sergeant Mercer, you indicated that you had contact with both Ed and William on that date.
Yeah.
When you had contact with William, did you make any observations of it?
He was the driver of the vehicle. He was very irate. He was talking to us partially, I guess.
And did you see any visible bruising?
I did not observe that. So based off of where he was at, where I was at, he was at the driver's side of his vehicle, obviously. I made contact with Ed. I had him step out of the vehicle. Then we went an actual car link behind to the back passenger side of a patrol car. So angle difference on that.
And so directly to the point though, you didn't observe any injuries?
No.
Did you observe any petechia?
I wasn't close enough to see his eyes.
And just to make sure, make a clear record, you know what petechia is?
Yeah.
Did you observe a raspiness in his voice?
Other than his usual tone of voice,
So fair to say you've interacted with William before?
Yeah.
And his voice wasn't any different on this date than it was otherwise? Did he appear to have any difficulty breathing at all?
I could not tell him. I don't know if he was having difficulty breathing.
Well, so you didn't observe anything that would tell you that?
No,
And he didn't say he was having any difficulty breathing?
no, he did not.
Did he indicate to you that he was assaulted in any way?
He was not willing to speak with law enforcement at any form.
Well, but again, so he never said he was assaulted to you?
No,
Did you ever go to the house and observe anything?
I did not.
When you observed Ed, what was he wearing?
I think it's exact close.
Was he wearing, well, I would say, what time of year was it?
It was summertime, July 20th.
Was he wearing long sleeves or short sleeves?
I don't recall whether he was wearing long sleeve or short sleeve.
And when you interacted with him, do you recall seeing any sort of scratching or injuries on him?
I do not.
I don't have any additional questions.
Thank you, Ms. Koch. Any follow-up?
No, Your Honor, thank you.
Sergeant, you can step down. Any further witnesses, Ms. Koch?
No, Your Honor.
Mr. Trush, did you wish to call any witnesses today?
I did, Your Honor. I would call the elder William Lamont.
Mr. Lamont, if you come forward. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Seated. Mr. Wilmot, you got the spelling of your last name, you need to state your first name for us.
William.
The traditional spelling of William. Oh, thank you. Mr. Truce, please proceed.
Thank you, Your Honor. So, Mr. Lamont, you've been in the courtroom and you've heard the testimony that was given by Bethany Lamont, correct?
Yes, sir.
Did you see the demonstration she made when she described how
Rear
you're?
naked choke. That's what she was trying to describe.
Did you see? Now you used a very specific term there. Can you tell me why you used that term?
Because a man has a rear naked choke on another man. No one is gonna grab their arm and pull it off for one. And for another thing, there's so many reason I wasn't moving is because that would make it worse. I do not want to hurt my son. All I was trying to do is for him to do this. We've done this several times. I told Bethany herself one time because she saw us almost get into it. Said, Bethany, do not worry. This is how we take care of things. And anytime I have no danger, I can whip that boy's ass in a minute. That's not the point. It's called a cuddle match. Two men were in combat sports. They want to settle argument without hurting each other. That's what they do. Gentlemen, it's a sport. It's not. That's what it is. That's how we've done it since she was 19 years old. She saw nothing. She finally saw one that got close. But the reason I wasn't moving because that's when you don't move. You want to get it worse, move. You want, and the officer did say that Bethany did say that the father did say, stop it. Calm down. That's what I was saying to him. Yes, I was talking to him because I didn't want to have to hurt him. It's that simple. She, even 10 minutes later, we're fine after these things. We took her to work, laughed, said, glad that's over. We'll pick you up after work. Obviously, obviously she's a doctor. She calls my wife an alcoholic. My wife may be that, but I don't know if that's her diagnosis. But the whole story we know, it was just a big misunderstanding. She came out of the room. Of course it was about a coffee cup. Well, son has a temper. I have a temper. But we have a way of dealing with this. I'm going to be 74 years old soon. And I fear, especially my son, I would never let him hurt me or anyone else. He's never hurt. He's never been arrested for assault and battery. Neither have I. This is how we settle it. I just wish people could understand the simplicity of what's happened here. The girl gets out of bed 4:30 in the morning. She don't know what's going on. God bless her that she's concerned. God bless her. She'd have been that concerned. Why didn't she run out the door? Call the cops right then. We took her to work. Everything was fine. They kissed goodbye, if I remember right. And as part of my wife and I coming in to talk to her, I absolutely do not recall that at all. So that would have to be proven to me because I would not do something like that. I'm sorry to speak my mind, but nothing's happened here except for a big misunderstanding and a waste of the court's time.
So, Mr. Lamont, I want to ask you some questions about some of the things you said there. So you identified, again, a rear naked choke. The position that Bethany's arms were in, would that be what that is called?
I wasn't, no, she didn't even have it right.
How do you know that?
Because I know that I can put it on you, but you can't show a rear naked choke with, you have to show by putting it on someone. It's easy to defend if you don't move. And when you want to get out of it, I mean, I know more than that boy's ever gonna know. I told her herself, I can get out of it at any time of any trouble I'm in. But apparently she didn't.
So I don't think you understand my question. You
Okay.
described a lot about a rear naked choke. Why do you know so much about that?
I've been doing this since I'm 19 years old, sir. My last fight, I was 63-year-old, right here in the Holiday Inn. I lost, but I've done it all my life, and I've taught him to use it in defense, not in aggression.
So it's fair to say that you are trained in martial arts
Exactly.
and your son is trained in martial arts.
To an extent.
And the two of you from time to time engage in this.
Man to man, yes, sir.
This is how you solve some of your problems.
Yeah, sometimes it's over enough to laugh, but it's over to, it doesn't always get so serious that someone has to get someone to usually do it to retire out.
So let me ask you, on this date, was there a point where you felt threatened?
No,
Was
she
there,
would have just stayed out of it. I was about ready to get out of it, to be honest with you, but I always try to talk him down and try to make him understand he doesn't have to do this.
was there a point where you felt anything was out of control?
Never.
Was there a point where you felt threatened or assaulted at all?
No. It was a mutual combat.
So is there any point in any of this where there was any unwanted touching of you?
Of me.
So did anybody touch you? Yeah, did you get touched in a way you didn't want to be touched?
Not that I didn't expect, no. It's part of the combat. It don't make him right, it don't make me right. It just takes the tension away. It doesn't say, okay, I'm right, I beat you.
Now, Bethany identified that your son has some mental health diagnoses. Is that accurate?
Yes, he does.
Have you gone through some special training and or counseling to assist him?
The only counseling or only training I have is when he first, I went to the CHS when all this mental things, when I realized he tried to hang himself, he had problems. I went there and begged him for their help. When they finally helped him, they had a counselor named Doug, I can't remember his name. And he was seeing this counselor, but I wasn't understanding what he was coming back with their faces. So I made an appointment to see the counselor. And when I had a long talk, because Ed wasn't telling the completely truth. After that, the counseling started helping because Doug had me come in. He would lie to Ed. I told him, lie to Ed, tell him you need to talk to me. We'd go in there, he'd tell me what Ed told him. I go, no, I'd straighten it up for him. So after a while, Ed couldn't lie to him. And Doug coached me for a year on how to deal with my son and his problems. And that's how I do it. That's the only qualification I have is from this great man who took the time to care about someone and help him and not just try to prosecute him every time he turns around.
So is that to say that he taught you things to help de-escalate it?
Yeah, it's hard to in the beginning, I would just didn't jump right back in and do that. But as a father, you need to calm down and treat your family, your children with respect so that you get that respect and help them, not just crucify them.
I don't have any additional questions. Thank you.
Stoke, any questions?
Mr. Lamont, how old are you?
I'll be 44 in a few days. I'm thinking about taking a fair enough box.
44?
74.
74, okay. And about, how much do you weigh?
140 pounds,
And your son, how old is he?
30,
And about how much does he weigh?
probably 150.
So he's 44 years younger and maybe 15, 20 pounds heavier? Is that correct?
Yes,
Has he had any training in, you said MMA style fighting?
I trained him all his life as a child. I didn't teach him how to hurt people. Taught him how to defend himself. After a while, he did get into it. So that's when he thought he became a man. And that's when he was 19. I had to show him he wasn't a man, and we started doing the scuttle stuff.
Now, you're indicating, now this hold that he had you in, it can be dangerous.
Can he?
Yep.
Yes, ma'am.
And studies show that in less than 10 seconds, it can put the opponent into being unconscious. Is that correct?
That he does on the opponent, quite frankly. It is.
Some people wouldn't necessarily be rendered unconscious.
Exactly.
It's meant to reduce the supply of oxygen to the brain.
That makes you give up, yes, or go to sleep.
And so it is your testimony that at 4:30 in the morning, you consented to be being put in a chokehold over a fight about a coffee cup.
That's the way you were set it, yes, because that's not exactly how it goes, but if that's what you see, thank you.
Well, what am I not seeing? What am I
You're
seeing?
not seeing it's not a matter of consenting to this or that. It's a matter of consenting to the combat. What happens in the combat happens. It's not a matter of, oh, you can do this, you can't do that. In a color match, it's automatic and legal, set. You can't do this, you can't do that. You're not gonna pick up a weapon, you're not gonna do things that will, seriously hurt someone. If you put that really good choke on them, you don't kill them. You just hold until they go to sleep, or they give up.
Was your son, telling you to go to sleep while he had you in the chokehold?
Of course, he wanted me to go to sleep. He wanted to end that way. He didn't want to just give up and quit. He wanted me to quit, but I wouldn't. I was just getting ready to get up, like I just said. And I can see this man here getting real ready to choke. Now, I'll show you how I can get out of his. He's a lot bigger than me.
How did the fight end?
We he went and got her ready for work. We got in the car, drove her to work, lapped it up, went home and smoked a joint.
Did Bethany agree? Did Bethany try to stop the fight?
Yes, that's what she thinks she was trying to do. I told her before not to ever interfere. That's on her, my
And when
pride and
she-
concern.
And when she tried to stop the fight, what happened?
It was over pretty much. It was ending, so I don't know. She backed up, went in the bedroom, got ready to go to work. She didn't, it was over.
Did you see him hit her while she was trying to remove his arm?
No. He was behind me. They were behind me.
So you couldn't have seen?
No.
I
But I believe her. I don't think he's touched her or hit her. He doesn't hit women. He doesn't hit children.
I have no further questions.
Mr. Church, any follow-up?
Very, very briefly. The prosecutor had asked you if someone were put in a rear naked choke, if they could go unconscious in 10 seconds.
They could.
In order for that to happen, their oxygen and blood would have to be stopped.
Yes.
And is it fair to say that when somebody is put into that sort of position, that's not always the situation they're in?
The situation of what, going to sleep or.
So if someone were to put you in a rear naked choke, that's not automatically stopping your blood or
Well,
oxygen.
not automatically, no. You have to hold it and get it firmly in. And someone who knows how to defend it will not let it get firmly in.
And I noticed the motion you're making there, putting your hands by your neck.
What, I mean,
I don't have any additional questions.
Okay.
Oh, thank you.
Thank you, Mr. Lamont. Step down.
thank you,
Any other witnesses, Mr. Church?
I know, Your Honor.
Any fellow witnesses, Ms. Hope?
No, Your Honor.
Anything in conclusion? Ms. Hope?
In this case, Mr. Lamont, the defendant, is in a different situation than most people who are not on probation. He is on probation for 2 cases, the first being less serious possession of analogs, and the second, which he got a pretty good offer. I think that's because of his mental health issues, why I gave him that offer, for having an explosive device. And he is required to not engage in any type of assaultive behavior. This is clearly an assaultive action. While Mr. William Lamont, not senior, but elder, of the 2, testified that he consented to this. When you look at the circumstances and you listen to Bethany's testimony about what happened, how it occurred, what she observed, it is clearly assaultive behavior. I'd ask to find the defendant guilty on all 4 counts of the probation violation. Thank you.
Thank you, Mr. Church.
Thank you, Your Honor. I guess I view these as sort of 2 separate things, and I'm going to address them in that way. Insofar as counts 2 and 4, which pertain to Bethany Lamont, I don't think on this record that there's sufficient evidence to support those, even by the lower standard. And I say that because while Bethany's testimony is that she was ultimately struck, her testimony was also she doesn't believe there was any intent to strike her, that it was completely incidental or accidental. I also think it's important to note that it's not as if, as was directly asked to her, was she trying to strike somebody else and struck you, like a transferred intent situation? I don't think that's the situation here either. She said he wasn't trying to strike someone. His hands were in a fixed position and she was pulling on them. So I don't think that there's a basis to find a violation or to find that a violation occurred in count 2 or 4. The more interesting question, I think, comes from counts 2 and 3, and those pertain to Ed's father, William. I think that's more interesting because I certainly understand the prosecutor's position in saying that, you know, he's in this unique position of being on probation that has these conditions that are sort of different than in the, you know, the normal world in general, which seems to suggest to me that she doesn't necessarily think that this would rise to that level if he wasn't on probation. I don't think that's accurate. I don't think that you can have an assault if it's consensual contact. I mean, if the person who is standing there and allegedly being assaulted is saying, no, this is consensual contact, I don't think that's an assault. This is a somewhat unique situation because both Ed and his father engage in martial arts, and they do this from time to time. They get into these wrestling matches. You call it a cuddle match or a wrestling match, whatever you want to call it. This is something that they engage in to solve problems, for fun, to relax, for whatever reasons they engage in this, but they do so consensually. They do so voluntarily. I understand that might not make sense to everyone, but that's what they do. And the prosecutor sort of pointed to their age difference or their size difference, which frankly, their size difference really isn't particularly large. The age difference is, but frankly, from someone who partakes in martial arts, I mean, yesterday I was thrown by a 65-year-old man. He threw me harder than people half his age have. It happens. And if you know what you're doing, it is a safe activity to engage in. I don't think an assault occurred here. I just don't.
Right, I listened very carefully to the evidence, first addressing the standard and the rules that the court's following. Probation violation hearings are governed by MCR 6.445E1. Under that court rule, the court is to provide an opportunity for both sides to present evidence and testimony. As I mentioned earlier, the rules of evidence don't strictly apply to these types of hearings. And the court is looking at this under standard of a preponderance of the evidence, or whether it's more likely than not that Mr. Lamont violated his probation in any of the ways alleged. In making its findings, the court has to comply with MCR 6.403, finds facts specifically, and state its conclusions of the law, either in a written opinion or through the record. In this case, we're dealing with 4 different alleged probation violations, all of which are alleged to have occurred on or about July 20th of 2023. Counts 1 and 2 involve violations of condition number 1, in that Mr. Lamont is alleged to have violated state law by committing an assault or an assault battery against William Lamont, his father, in count 1, and Bethany Lamont, his wife, in count 2. Counts 3 and 4 deal with alleged violations of condition 4.18, that Mr. Lamont engaged in assaultive behavior at count 3, directed at his father, William Lamont, and count 4 directed at Bethany Lamont. Looking at the evidence, in my view, based on the testimony of both Bethany Lamont and William Lamont, does appear that there was some physical contact that occurred on that morning, early in the morning, 4:30 a.m. between the defendant and Mr. Lamont. I think it's clear based on the testimony of both of those individuals that it involved some type of direct wrestling or physical contact involving Mr. Lamont, the defendant, putting his arms around or hands on Mr. Lamont, the father, during the course of this engagement. So the court finds that there was physical contact that occurred. The question is whether or not it amounts to what would equate to a violation of state law by being an assault battery, or whether it's assaultive behavior. With regard to the crime of assault battery and a violation of state law, even under a preponderance standard, the court finds, based on the testimony of the father, Mr. Lamont, that there isn't sufficient evidence to support a finding that there was an assault and battery given that he indicated that it was some type of consensual contact between the two of them. The court also finds, based on Bethany's testimony, that there isn't sufficient evidence to establish that there was an assault battery intentionally committed against her. And the court also finds, as to count 4 assaultive behavior directed at Bethany, the court finds, based on her testimony, that any contact between the two of them was a result of her trying to get Mr. Lamont off of his father, not any intentional conduct on his part. So that leaves us with count 3, which is assaultive behavior, and I think there was assaultive behavior here. This wasn't a circumstance where they were, at a gym engaged in a sparring contest, which I assumed was the kind of venue for your thing, Mr. Trush. I think there was an argument between the two of them based on the testimony of Bethany in particular, but also based on the testimony of Mr. Lamont. And I think this was a wrestling match that occurred as a result of that argument in their home that morning. And I get that different people find different ways to resolve things, but if their way of resolving disputes was to beat each over the head with baseball bats until one of them gave up, I think that would clearly be an assault. So, that's an extreme example, but I don't think that, particularly given the defendant's position of being on probation, that's an appropriate way for them to continue to resolve disputes. I think one or both of them have to, at some point, decide that, at least while Mr. Lamont's on probation, that they need to resolve their disputes verbally and not by engaging in physical contact. And just looking at while the hearing was going on, I just looked up the standard definition of assaultive behavior. And it's physical actions which are likely to cause physical harm or likely to cause a danger of physical harm to an individual or others. And there's no strict definition for that condition 4.18, but I think if we just use that very basic common sense dictionary definition, Lamont did engage in actions towards his father, which could have resulted in physical harm or the danger of physical harm. So again, I think under a preponderance standard, there was clearly conduct, assaultive behavior directed at his father by the defendant in this case. So the court finds that there is a violation of 4.18. And so the court finds that violation. In terms of sentencing, Mr. McFalda or Ms. Cope, did you want to prepare a pre-sentence report and have this set for a separate date?
Yes, Judge, I'll do a report.
Okay, so the court will set this for hearing. How much time? Right.
I could have this. I guess it's early February, so starting next week in motion day. So early, I would be ready by early February.
So
what we're going to want to do is talk about the underlying case based on what they recommend. So, for example,
Mr. Trush, any further?
No, Your Honor, thank you.
So
Now, I would just ask to, I believe, Mr. Lamont Senior here, I would ask to remind the defendant that he is not allowed to possess firearms or have any firearms in this house. It's not related to this issue. I just wanted to make sure I said that on the record. We've had some issues.
thank you.